Well, hello, everyone. Happy holidays to you all. Scott and I wish to express our appreciation for you following our videos this past year and to wish you all a very happy holiday season. And we certainly look forward to working with you through our videos in 2025. And we're happy that you're able to join with us again for a short discussion of recently issued compliance-related items from the various agencies. And so without further delay, we've got our setup here of our opening slide of all the different items that we wish to discuss here in this video. In particular, we have a couple thresholds that we wanted to mention. Scott is going to take you through a whole host of CFPB items. They've been busy here this last December trying to issue a bunch of information. We have some FinCEN items, a couple of FDIC updates that were released, an IRS notice that we wanted to make sure that you were aware of because you might have customers either asking questions or coming in with potential checks to negotiate. We have a couple OCC items, and then finally some interagency releases that, again, we want to make sure are on your radar here as you plan your joining in the upcoming year. So first off, we wanted to go through two thresholds in particular. Now, the reason why we included these thresholds were these were items that were issued by the agencies and by the CFPB after we went to print with our December compliance journal. So for a whole host of 2025 thresholds, please do take a look at the December edition of the WBA Compliance Journal, which is out on our compliance page for you, because we do have a whole host of the broader list of adjustments that are made each year by the Bureau and by the agencies as it relates to inflation adjustments. We also have the DFI escrow rate included in that edition for 2025. But here we have two adjustments that were recently released here. One is the Reg Z adjustment to the asset size for banks to be exempt from the requirement to establish an escrow account for first lien high price mortgage loans or HPMLs. And we have two bullet points here because, as you recall, there's actually two different calculations that are encapsulated within that particular rule. And originally, back 2013, 2015 is when we had those rule adjustments. And we originally started off with a small creditor adjustment, which originally had a $2 billion mark. That has since over the years continued to increase. And for 2025, the small creditor exemption asset size threshold has been raised now to 2.717 billion. So it keeps going up a little bit more. That's the threshold that you're going to want to look into if you're falling into the small creditor exemption. The other exemption, which is typically referred to as the insured institution exemption, that insured institution exemption is also increasing. So if you go back again in time to the 2015 rule, that originally started with a $10 billion mark. Those over years have increased, and now we're up to the $12 billion.179 as the threshold for the exemption mark underneath the Reg Z rule for not having to establish escrow accounts for high-price mortgage loans. Now, Scott and I didn't put through all the other components that need to be part of that calculation or part of that exemption, I should say, because there are multiple components to meet that exemption. We wanted just to focus on the inflation adjustment for the asset threshold. So we have those there for you. We also have for you the CRA asset size threshold, which fits into the definitions of small bank and intermediate small bank. So each year, as you well know, the agencies take a look at those figures and adjust accordingly. And here again, we have some changes for 2025. So for small bank, you would be considered a small bank underneath CRA rules if, as of December 31st of either of the prior 2 calendar years, you had assets of less than 1.609 billion. Also, by definition, we have the adjustment for the intermediate small bank definition. And so for 2025, that threshold will be assets of at least 402 million as of December 31st of both of the prior 2 calendar years, but less than 1.609 billion as of the 31st of December of either of the two prior years. So I know it's a lot of words. We're all quite familiar with those thresholds, but wanting to make sure that you knew of those new dollar amounts for 2025 as we go through that. And with that, I'm going to then turn it over to Scott, who's going to run through all of the different, or many of the different items that the Bureau has released here in the last few weeks. Scott?
Yeah, thanks, Heather. And as Heather mentioned, CFPB has been quite busy here, so we have quite a few items to cover. Just at the outset, we'll say that much of this is intended to be informational as well, meaning you might be listening and going through this and seeing that it's not directly related to banks. And so there might not be specific aspects to cover in that regard, but we did want to include it more so to make you aware of what's happening in the broader industry. So with that, we'll start with, we've got it broken down into three categories here. And so our first category is CFPB court activity. And again, we've included these more to make you aware. So this is more of a news section here, I suppose, within the industry. And we've got links in the descriptions below for each item. So if you do want to know more, make sure to take a look. So the first lawsuit here involves Rocket Mortgage. And CFPB is alleging that Rocket Homes provided kickbacks to real estate brokers and agents that were designed to steer prospective borrowers toward Rocket Mortgage. So in this suit, CFPB is stating that Rocket Mortgage engaged in this kickback scheme, part of that being to discourage home buyers actually from comparison shopping and pressuring real estate brokers and agents to then not share valuable information with their clients concerning products that might be offered by others that weren't offered by Rocket Mortgage. CFPB also states that in its investigation, it found that Rocket Homes had given referrals and other incentives to real estate brokers under an agreement that those brokers and agents would refer the business instead to Rocket Mortgage. So disincentivizing from others and directing and steering toward Rocket Mortgage, and a separate Rocket affiliate as well that handled title, closing, and other escrow services. So CFPB stated that it found that those agents were trained to suggest that housing settlements could fall through, suggesting this to their clients, right, could fall through if the home buyer wanted to comparison shop with any of the competitors. So in short, CFPB was looking at here alleging both illegal kickbacks for those referrals and steering. Now, in the second lawsuit that we have here, you'll see that it involves Walmart and CFPB alleging what, in summary, it's stating Walmart is doing in illegally opening deposit accounts for its workers, then charging junk fees on those accounts and deceiving the workers about how to access and how to use those accounts. And so this lawsuit alleges that Walmart, again, opened these accounts for their drivers, then deposited their drivers' pay into those accounts without consent. So automatically doing this for all their drivers. Then telling the drivers that they were required to use these accounts to get paid and that they would terminate any workers who did not want to use those accounts. CFPB also alleged that Walmart misled workers about features of those accounts, how to access those accounts, complicating the instructions for using those accounts and access to the funds, incorporating delays and fees then if the workers tried to then transfer or move their funds out of those accounts into others, which ultimately CFPB found resulted in workers paying more than $10 million in fees to transfer those earnings to other accounts that they might have choose to want to use. So that's the second one. Then the third and final lawsuit here, CFPB sued Zelle and 3 of the largest banks for peer-to-peer fraud. So just a bit of context on this. The lawsuit involves early warning services. So early warning services operates Zelle along with 3 of its owner banks. So the lawsuit alleges that the Zelle network was developed, in short, without properly implementing effective consumer safeguards. And so within the investigation of this, CFPB is alleging that because it was not properly developed for risk and safeguards for consumers, that it actually resulted in more than $870 million, again, that CFPB is trying to tie directly to a result of this. The lawsuit alleges that Zelle's identification verification methods were insufficient, corrective action was too slow, resulting in repeat offenders able to carry out fraud more effectively than they should have been, ignoring red flags, and failing to assist customers who reported fraud. Again, just kind of summaries there. We wanted to include those more to make you aware of the fact that CFPB has been busy, that CFPB has been taking these enforcement actions. And again, if you want to know more, CFPB's releases are all in the links below. So there's additional information and the complaints themselves if you want to take a look. But now we do want to move away from lawsuits into our next CFPB segment, here talking about warnings and reports. And we have two here for you. In the first one, CFPB has issued a warning against illegal devaluation of awards, rewards, and other unlawful practices, specifically highlighting here issues with retail credit cards. CFPB also mentions within this report and warning that it's created a tool and launched this tool with more info and a link to it that's designed to help consumers find cards with lower rates. So shop around and do comparison shopping. But specific to the notice and the warning, CFPB is really focusing and honing in on UDAP violations here. Specific to clarity and advertising of rewards, primarily related to bait and switch tactics. So those that would lead customers to say, hey, this card has great rewards, great programs, and would choose it for the value of those benefits, only for those to later lose value in a way that the consumer wasn't anticipating or be revoked in some way, or just can't be accessed or used in the way that they expected. Or similarly along those lines, otherwise being hidden, maybe the conditions for earning or keeping the rewards that they were there, but they were tucked away in the fine print, so to speak, that they would be canceled, that they had otherwise earned. Also mentioned within this is a warning that with respect to rewards, they should be ensured that any systems involved in that and the administration of the awards are capable of coordinating with merchant partners and vendors to ensure that customers are adequately able to redeem those points. Then this next one. So this relates to successors and interest in servicing practices. And I know we've gotten some calls on this. Some of you have dealt with some of these situations. That being after divorce or death of a spouse or family member. So where you're working with a homeowner who is inheriting a home. So they're not a borrower, they're actually inheriting the home that is subject to that mortgage. That could be spouses, it could be children, adult children who are inheriting the home from their parents, maybe domestic violence survivors or a divorcee from just a typical divorce. But if there's a mortgage involved, then those new homeowners, of course, need to potentially take action to make sure payments are made. That might include may or may not wanting to assume the mortgage itself. And that process all starts, of course, with knowing where to send the payments, knowing how much the payments are, what the principal balance of the loan is, what the loan terms are. And so if the mortgage is past due, then they may need help in avoiding foreclosure. And that's all fact specific as well, of course, right? So just one example, a divorce will involve a court order, and that court order might even specify assumptions of liability. So you might even have a court order specifying what's to happen with liability. Of course, then that's where CFPB servicing rules come in, requiring procedures for assistance for these owners. And in this alert that CFPB has put out, it's reporting on complaints that it's gotten. And so CFPB is saying, with these situations and with a variety of different situations, we've been fielding complaints from consumers, primarily saying that, hey, it's difficult to work through this process. It's difficult not only to get the information that we need, but also get the help that we need. Or CFPB is hearing reports where consumers are maybe being pushed in certain directions, maybe being pushed toward a refinance, maybe they're being delayed, maybe there's even refusals on working with them or blocking or other issues regarding, for example, maybe the release from liability situations, right, where it's maybe even ordered by a court. And they're trying to work through this process that has resulted from litigation. Or maybe again with survivors of abuse, right, where they're dealing with a situation where they're finally getting help that they need to get out of a dangerous, abusive relationship and situation and looking for assistance on that and their safety risks, right? Regarding privacy of information from the abuser who might have been the previous owner. So those are just examples, just summarizing, highlighting that. Those are discussed quite a bit more detail within CFPB's alert. And then lastly, we do have some rules to cover here. First, I believe we've talked about PACE financing in the past, and CFPB now has finalized its rule. This is really specific to PACE lending and really kind of predatory practices that Congress was concerned about when starting this sort of PACE financing program and requiring CFPB to implement some safeguards. I guess at the outset, though, PACE being property assessed clean energy loans. So these are loans that a consumer would use who wants to accomplish some clean energy upgrades to their home or disaster readiness that are then going to be paid back through their property tax bills. And so again, CFPB is set forth by Congress to enhance the protections, ensure that borrowers who are looking to engage in these programs and obtain PACE financing have the right to receive the standard mortgage disclosures, right? That will allow them to make all the decisions that any other loan subject to those disclosures would do, compare the cost of the loan with other forms of financing, and ultimately make that decision. And that the lender will be responsible for ensuring that the loan is affordable. So, long story short, these are rules that are largely targeted at preventing lenders from luring homeowners into what they might think is an affordable loan based off the premise of energy savings, right? But for anyone who's looking to engage in PACE financing, it's worth taking a look at this. Really quick then on these last three. So overdraft rule, this one relates to truth in lending coverage for overdraft loans for very large institutions. Long story short here, the rule provides options for either giving an overdraft loan under truth in lending or subject to certain restrictions. For example, capping fees at $5 to maybe instead offer overdraft as a courtesy. And so then only the fees that would be charged are those that are to cover the costs or potential losses. Alternative to that, the overdraft program can simply comply with truth in lending provisions. Obviously, there's more within the rule, but again, just kind of as a summary, with regard to that, CFPB is looking to close a loophole that otherwise would have kept those loans out of truth in lending coverage. Then we'll cover these Reg V rules really quick as well. So these are proposals. The first one, in short, is designed here largely to make sure that the FCRA's protections are applied to consumer information, including that information which is sold by data brokers. And so it would do this by tweaking the definition of consumer report and consumer reporting agency, as well as certain of the FCRA's provisions governing when consumer reporting agencies may furnish and users may obtain consumer reports. Then lastly here, CFPB has issued a advance notice of proposed rulemaking. So this is CFPB is primarily just looking for information here, but they are going to issue a proposed rule following this. So in this, they're looking for info on rulemaking that's designed to address the harmful effects of inaccurate credit reporting, primarily that which is affecting survivors of domestic violence, elder abuse, and other forms of financial abuse. For example, someone who is forced into making a credit decision, right? Somebody who's forced to sign and enter into this obligation under maybe threat of violence, coercion, or other abuse, where somebody is, right, led into this credit transaction that they might not otherwise want. And so CFPB is essentially saying, looking at this, we're looking for comments that's related, anything related to this topic. Primarily, though, evidence of this coerced debt, right? So is there any evidence of this coerced debt and how it is tied to that credit risk, right? Again, the premise being that somebody is coerced into this obligation that then creates credit risk, that creates harmful effects and credit reporting on this individual, harming their credit that they wouldn't have otherwise wanted. And examples of challenges that are related to those coerced debt as well. So again, advance notice proposed rulemaking, just in the information gathering stage on this one. But CFPB has been busy. That wraps it up. Any of those items that you want to take a look at, again, links in the description below. But with that, we will wrap up CFPB and I'll hand it back off to Heather.
Super. Thank you, Scott. Also, just as a follow-up to Scott's mention there has been a little bit of litigation on that overdraft proposal or final rule that Scott mentioned, so keep an eye on that. And even though that rule does apply to a very large institution, there is likely a trickle-down effect. So you're going to want to take a look at that rule just to kind of be aware of it. because it may ultimately apply just more generally across the entire industry. So just FYI. But as Scott mentioned, we do have some FinCEN releases that we wanted to include here in our conversation today. One being an alert. As you can probably unfortunately guess, we've got fraudsters who are aware of FinCEN's recent activity being out there trying to work with business customers, primarily on the beneficial owner information reporting rule and making sure that those companies are reporting as they need to. And through those efforts of FinCEN, people who are trying to scheme, unfortunately, are using FinCEN's name or their insignia, or otherwise trying to misrepresent that they are working with FinCEN. And through those efforts, unfortunately, some businesses are being scammed by sharing non-public information with these bad actors. And so as a result of that activity and other activity, FinCEN wanted to make sure that people were alerted to the fact that there has been misuse of their name and their insignia. So the alert has been issued just to put everyone unaware of that. And again, it's being used in the beneficial ownership information reporting world, also with MSB registration through their tool, and just, again, generally misrepresentations that someone is working for FinCEN. So this might be an opportunity for you to reach out to your commercial customers and just once again remind your commercial customers to always be careful with whom they are working with, and that they are really working with FinCEN directly from the official website of FinCEN, and just to always double check who it is that they're working with before sharing of information. There are some helpful tips within the alert, which we have provided with part of this video. We also wanted to give you an update on the beneficial ownership information court case. There's been a lot of activity in this particular area. As you may recall, the FinCEN was sued by a bunch of business groups who are wanting to stop the enforcement of the Corporate Transparency Act, therefore stop the implementation of the beneficial ownership information reporting requirements. And when that first court case was filed, the district court actually enjoined the enforcement of the reporting requirement, which put everything on hold. That was immediately appealed. That decision was immediately appealed by FinCEN, and we have a link for you to the Court of Appeals of the Fifth Circuit decision, which reinstated the enforceability of the Corporate Transparency Act. So in essence, the rule is back on. So it lifted the injunction. As a result of that particular step, FinCEN did post an update to its BOI website that has delayed the effective date from January 1 to January 13, taking into consideration those court action time periods. And so now reporting by companies to FinCEN who are supposed to have met the January 1 effective date now have until January 13. So the rule is back on. Your business customers should be aware of whether they need to report or not based upon whether they're exempt or not. And the FinCEN has a great resource of information on their beneficial ownership webpage, which if your customers have questions, you should feel comfortable referring them directly to FinCEN and those resources, including that notice of the 13th date, which we've included for you in the link. So those are the FinCEN items that we wanted to update. We then wanted to go to FDIC. We've talked about this a couple different times, the resources made available for the revisions to FDIC's Part 328 rule, as we referred to it. That is the rule that talks about how we are to mention that a bank is member FDIC and how we are to use references to FDIC insurance and advertisements. They have created a series of frequently asked questions, an FAQ, that's been out there now for several months, and they've just recently done another round of updates to that. So there's a December date now included into the FAQ. So when you look at those FAQs, which we've again provided you a link to, the nice thing is they've added dates into each question, so we know which question then has been updated within the most recent version of the FAQ. FDIC had committed to one more round of a webinar to be hosted on this topic of the Part 328 rule. As of the time that we've done this video, they have not mentioned when that fourth webinar will be, but keep an eye on the FDIC's website for resources because they have committed to one more video webinar, I guess you'd call it. And they have posted the past webinar materials for the previous 3 webinars that you can rerun if you have further questions and want to hear their instruction on that particular rule. We also wanted to make sure that you were aware that their consumer compliance manual has been updated, mostly for technical changes that we won't run through, but just FYI, that manual has been updated. When you look on the table of contents page, you'll see a December 2024 date of the sections that have been updated for you. We did want to make mention of an IRS notice that was recently issued about special payments to taxpayers. And these are taxpayers who qualify but did not claim their 2021 recovery rebate credit. And so there are roughly 1 million people who are going to be receiving this credit. IRS is going to be separately notifying each individual by mail of them receiving the credit. And the IRS will either be directly depositing that credit into the taxpayer's deposit account or issuing a check made payable to the individual. The dollar amounts of the credit will vary based upon factors underneath that particular rule, but IRS has said that the maximum amount could be up to $1,400. So again, we just wanted to make sure that you were aware of it. Maybe let your frontline teller staff, CSR staff know about this in the event that they may have persons wanting to negotiate an IRS check at a kind of an odd time of the year, but those credits are going out to taxpayers as of December here. We also then wanted to talk about, very briefly, some OCC items, in particular 2 reports. And while most of us on the call are compliance focused, sometimes our job duties do tend to creep into the safety and soundness realm. And these particular reports are helpful, primarily in the safety and soundness, but again, with the multiple roles that we all play, it's good to know of this information specifically about risk. So the first item OCC has issued is a semi-annual risk perspective for the fall of 2024, where it's gone through a number of different risks, as we have outlined here on this slide for you, and identified for each risk where are we seeing trends from moderate signs to an elevated risk to an area such as CRA, which is remaining stable. And there's commentary around each of these risks of what OCC is seeing nationwide. Very helpful to your own self to help identify of the items that are listed in the report or contemplated in the report, what does that mean to me at my financial institution, and comparing and contrasting those risks to gauge out where one might want to focus in on or at least be aware of. Similarly, the annual report by OCC has a similar helpfulness from that aspect of prioritizing one's own risks and interests based upon what OCC has identified as their own strategic priorities. In examinations, this might ring through of what their priorities are from a regulatory and policy standpoint. You can then expect examiners to be asking particular questions that come through. So I wanted to provide you with both of those resources in the links below. So with that, I think I'm going to turn it back over to Scott here to talk about some interagency releases that came through.
Yeah, so the last set of updates we have for you are from the agencies jointly. And the first item is a release concerning data on small business, small farm, and community development lending during 2023 under CRA. And so in addition to this data, the agencies have also prepared aggregate disclosure statements of small business and small farm lending for all of the metropolitan statistical areas and non-metropolitan counties in the United States and its territories. The agencies have also issued a statement to provide examples of risk management and other practices that may be effective in combating other financial exploitation. And of course, we know this continues to be a big issue for banks in Wisconsin. So in looking for tools and looking for strategies, ideas, make sure to take a look at the link below that has this statement within the bottom in the description of this video. Then EGRIPA. So the review continues here. We've talked about this before, this being the third focus. And so this process previously, you may recall that WBA did comment and created a template letter as well. So thank you to all of you who commented and maybe took advantage of that letter. This next focus is different from that, but you'll recall that part of this review process, the agencies are rolling it out in segments. And so this third one involves rules of procedure, safety and soundness, and securities. So with that, we will look to wrap up our December compliance corner here. This, of course, being the last compliance corner of 2024. But before you go, just a quick mention on resources, and we do have some new ones. So this isn't just a repeat here. We have all of the great other resources, of course, available to you. So the call program, thank you to everyone who called in 2024. Looking forward to working with you again in 2025. If there's any training opportunities that you might be looking for, make sure to take a look at that link and the information on our website, or just reach out and we can tell you more. But with regard to new resources on our website, we of course have our compliance page. And so the compliance page is the one that you find on the main WBA website under news and resources. And so you get the new compliance journal. You get all the old compliance journals. There's a link to all of our comment letters. And there's, of course, these compliance corner videos on that. But there's also a new resource. So we have an updated CLE listing for you, for those of you who are attorneys and want to see what credits you're eligible for if you have reporting maybe even coming up here in the next couple months. We also have a new chart that is designed to help show what the agencies are up to. So that can be found on that main page there, next to a update for Reg CC thresholds. So again, as the Reg CC thresholds change from time to time, make sure to take a look at that for purposes of funds availability. Then separately, we also have the best practices library. And within the best practices library, there's of course a compliance section. And in that compliance section, we have a brand new Wisconsin Banker's Guide for you that relates to banking minors. And so it's quite comprehensive in what it has regarding deposit products, other services, and even loans to minors. So it's not just WMAs, although there is quite a large WMA section in there, including a Q&A and a reference chart that you may find helpful. And then we've also updated the legal call program FAQ. Up to about 29 questions in there now. So almost doubled the amount of questions that are in there. Again, based on questions that we receive frequently, designed to kind of give you a start on that. And then give us a call as you have more questions, or the unique facts or twists and turns always come up in that, right? So don't hesitate to give us a call through the legal call program whenever you're working through a scenario like that. But with that, we will see you in the new year. Thank you, everyone.